So I recently was able to get someone £4,500 compensation for a data breach. I'm going to talk a lot more about it because it actually stems from a case I've been working on for 12 years. It actually relates back to the whistleblowing I did at Bedford Borough Council, because this breach involved exactly the same thing which I whistleblew about. And effectively, lots of twists and turns on the way, but effectively senior council officers didn't take the concern seriously. In one case, actually disregarded their own legal advice and proceeded to break the law anyway. And then in dealing with the complaint, and I'll talk a bit about this now in this video, in dealing with the complaint, they essentially just used all kinds of unlawful nonsense kind of arguments to say that what they were doing was okay. And I guess it's just worth, before we get into it, explaining why data protection is so important. A lot of people, a lot of professionals roll their eyes when they hear data protection. They're like, oh yeah, just that, it's really annoying, it's this kind of millstone tied around our neck sort of mentality. But the reality is that data protection law stems from human rights law. It's based on the fact that people have a right to a private life, and that no one can interfere with that unless there's very good reason. And within the homelessness sector, the only time you're really going to see that principle being breached is when someone's broken the law. Pretty much for every other situation, you're going to find the individual needs to know what's happening in full detail and have explicitly and kind of, properly given consent to that. And what we find is that data protection law becomes this window into the soul of the council or the organisation or the charity, whatever. Because every council, every charity will kind of tell you, they kind of put in their social media how great they are, how much they value the individual, how person-centred they are, and all the rest of it. And yet when you look at how they're using client data, when they're dealing with this highly sensitive information on a daily basis, you just see kind of how that myth kind of falls away, really. And the reality is that often what is happening in practice, they won't say this is happening, they won't admit it, but what they're really doing is they're kind of objectifying their clients, boiling them down into essentially how much funding they can get out of them, and basically disregard their rights. And I'm sure people will be pissed off with me saying that. I'm happy to have a debate with anyone about that in terms of what data protection breaches across the sector says about what we really think about the people we're helping. But I'm not going to talk about that in this video. This video I'm going to talk about how do you actually find out that a breach has happened and how do you get compensation for it. It's not just about getting compensation for the individual, although it obviously is that. What I'm hoping is that if people were to do this more regularly, you're essentially going to push up the standards of practice within the sector, because if charities and councils can't be trusted to respect the rights of clients because it's the right thing to do, then I guess the next best thing is to get them to respect the rights of their clients, because essentially there's a financial impact if they were to breach it. So effectively what I want to try and do is put the information out there so that people can do this themselves. And although I did need a solicitor in this most recent case, I did have quite a lot of success actually in previous cases without a solicitor. The good news is that I think, and I'm saying this in 2025, so obviously time changes, I don't know how long this video is going to be up online for, but I think it would be possible actually to use this kind of way I found of getting a solicitor involved to potentially roll out to a lot of people, because effectively if you're on kind of low income or if you're on universal credit, you'll be able to claim legal aid for this type of case, which basically means it's realistic to actually get kind of court involvement and actually get a much better outcome. So again, I'll do a bit more big picture before I get into the nuts and bolts, because I think it's essential to really understand where I'm coming from with this video, because again, I know this is going to piss a lot of people off. But I was speaking to someone recently, actually this week, had a really good conversation with her. I'm not going to name her because I don't know if she want to be publicly associated with me, but anyway. But basically she was making the point that, we talk about homeless people as being invisible, and yet the reality is that often homeless people, without their knowledge often, are spread across lots of different kind of spreadsheets and kind of databases, and they're discussed in different forums without their knowledge. And actually they're not invisible at all, they're well known to services. And actually the extent of that, I don't want to make people paranoid, but the extent of that happens, it might actually kind of scare you. I'll give you one example in Bedford. So treat this next bit with a pinch of salt. I haven't fact checked this, but there was a time when Bedford had more CCTV cameras than any other place in the country proportionally to its population. Again, I'm not 100% sure of that. I've actually been into the CCTV centre before, and it's kind of like, like a film really, it's like a wall of TVs everywhere. And at one point in the saga, they were essentially looking like they were going to use this CCTV basis to find people, to find known rough sleepers for no good reason at all, basically just because they could, it seemed. So yeah, that kind of raises various questions about how CCTV is being used in Bedford, but that's an aside. I guess the point I'm making is that when people approach homeless services, whether they be council, whether it be a charity, whether it be some other kind of service or something, they might not realise how their data has been really used, and I can guarantee you they will not be told the full extent of how their data has been used. And in fact, in my experience of training on data protection, if you ask most professionals what does their privacy notice, their privacy policy even say, they wouldn't have a clue to understand it themselves, let alone explain it to someone who's currently rough sleeping or something. So yeah, that's going to be something which is probably worth bearing in mind. And again, I don't want to make people paranoid, but certainly if you've been risk of serious domestic abuse, or if you've been a street drinker, or if you've been rough sleeping or something like that, the chances are your name will be discussed, your life will be discussed in some meeting somewhere by professionals who probably don't have your best interests at heart. So hopefully that kind of gives you a bit of an overarching kind of idea of what this is all about, and then kind of helps us frame actually how you can kind of get compensation from an individual breach. And I'll talk about a couple of cases. I'm obviously not going to name them for obvious reasons, but let's just kind of group them together. So one type of cases I've dealt with before involved these kind of multi-agency meetings, and another involved data sharing of libelous information between different controllers, the different organisations basically. I've done a video about that kind of libelous one where someone was told they were scheduled an offender when they weren't, and that data was then shared with other people. I'll kind of talk about that, because actually if there's one thing I learned is that they should have got a lot more money. So this is when we were starting out, we hadn't got a clue what we we're doing our best at the time, and effectively the client accepted £2,000. Knowing what I now know about case law and about, you know, effectively being libelled and being called a scheduled offender, the chances are that it should have been 5 figures easily, if not sort of, 20 or 30k or something. But anyway, yeah, we've kind of done the best we could along the way. But what I'm seeing is that even for, I'm not going to say not serious breaches, because they are serious by the nature of what they are, but I guess by the common sort of breaches you'll see every day in a lot of organisations, you are looking at between 2 and 4 and 5, even 6k sometimes, just for very basic information being shared about you without your knowledge. And so at this point, I guess I'm going to introduce a couple of terms. I'm actually going to put the full training I do on this onto YouTube at some point soon. So if you want to know more information about it, do check that out. But for the time being, let's just say that there's personal data, which is any information that identifies a person, a living person that is, and then you've got special category data, which is effectively more sensitive data, so things about your health, about your sexuality, about your sex life, that sort of thing. And often all of those things will be discussed in those meetings. So your drug use, that kind of thing, all comes under this special category data. Potentially offending history does as well. And so often when, if you're homeless, the nature of your homelessness means that the council, the charity, whatever, will be discussing and processing your special category, your sensitive data. And effectively, as what very frequently happens in the sector, is that data will be misused in a number of ways, some of which you can basically very, very clearly prove, which is, I guess, important. I'll tell you a story actually about an old colleague of mine. She used to work in a local charity, and they had access to one of these kind of fancy data kind of record keeping databases or whatever. I can't remember what it was called. I think I know what it's called, but I'm not going to get it wrong here. So basically there was a situation where she saw her colleagues gathered round this computer, looking up this individual, looking up their kind of past case notes from a different organisation, because this system basically gave them access to it, and effectively having a good laugh about that person's situation. Again, I'm not trying to make people feel paranoid, but part of the reason I feel so strongly about this is just how sort of grubby and unpleasant a lot of housing charity workers can be, because obviously that was unlawful, but clearly it wasn't that unusual, I don't think. And clearly there were other issues, even if they hadn't been having a kind of good laugh about it. The fact they had access to so much information was troubling, because I doubt those individual data subjects themselves would have understood the implications of kind of giving their data over. So yeah, we're talking here specifically about special category data, although it would still be a breach of the Data Protection Act if an organisation misused just normal personal data, so your name or date of birth or something like that, and that would basically attract a much lower amount of compensation. I would still say there would be maybe a few £100s in it just for that alone, depending on the circumstances. Unfortunately, within data protection law, the fact that you are homeless itself is not special category data, it's not considered sensitive. Although I would say it's good practice to treat it as if it is, because clearly the fact that you've been homeless could potentially kind of lead to prejudiced opinions about you further down the line. So yeah, anyway, but it's not technically special category data. Let's just kind of start at the beginning of a process. You're homeless, or you're in need of some kind of support from an organisation. You approach them. Really, on day one, they should give you a comprehensive explanation of how they're going to use your data. Now, it's on them to do that. And bearing in mind, lots of people who are rough sleeping have obviously got bigger things on their mind right now. And the law is very clear that actually it's down to the organisation to find a way to accurately convey that information. At the very least, it needs to be given them in a hard copy, in a readable format and an accessible format, so it's not using lots of jargon and so on. That would be an absolute basic requirement. That has to be done within 30 days. Quite often what happens is people just get thrown a privacy notice, which is the name of the policy. When they approach a service, they're not given any explanation for it, and the privacy notice itself won't actually explain how their data has really been used. But that document's important, partly because it'll actually give you the contact details of the data protection officer, the kind of head honcho for data issues in that organisation. And it should also give an explanation of how your data is used. Now, as I say, if you're homeless, you've got bigger things on your mind at that point in time. But if you have got headspace for it, I probably would highly recommend reading through those policies just to see how data has been used. As I say, lots of privacy policies don't actually explain what's really happening, and that immediately sets that organisation up to be in trouble if that data subject, if that individual finds out down the line that their data was used in a way which was not explained to them. Because one of the underlying principles of data protection law is that the organisation needs to be transparent about how they're using data. The exceptions would be around things like, investigating fraud, investigating crime, that sort of thing. But for pretty much any other situation involving homelessness, the individual needs to know about it. In some situations they need to give consent for it, and if consent's not the reason for processing that data, they need to be able to object to it. So in one sense it doesn't really make much difference which basis the organisation's using. The individual has to know fully what's happening, and they need to basically be able to have control over that. So as I say, consent is a very specific thing within data protection law, but if, let's say, an organisation is going to use a different basis like legitimate interest, the person still needs to know about all of that, and they still need to be able to opt out of it. So it kind of doesn't make actually much difference for the person which basis the organisation's using, as long as they're happy with the information and how it's been used, and they understand fully how it is being used. Then that's your litmus test. And actually, the whole day's training I do about data protection law boils down to those two things. Does the person know how the data's been used? Are they happy with it? If the answer is yes to both of those, you don't have to worry too much about the ins and outs of it. To be honest, the rest is common sense. So that's the privacy notice. You need to familiarise yourself with that. The next thing you need to do, and this is not an urgent thing, as in, you don't need to kind of do this straight away if you think there's been a breach, and often you won't even know a breach has happened. So often you're going to find out about this should you make a subject access request down the line. So I've introduced another bit of jargon there. A subject access request is a free thing to do, which basically enables you to access all of the information that a data controller, an organisation, holds about you. Could be a charity, could be a council, could be whatever. There has to be something on their website really which explains how you make a subject access request. Although it's a bit like a homeless application, you don't have to do it in a particular form. You can do it any way you want. You can do it via an email. In fact, I think I even did a video on this channel which is like the best way to get your records. So there's a lot more detail there about making a subject access request. And you'll generally have to kind of chase the council. They might not provide all the information. They might go over the time limit and so on. So I've had to complain before just to get the council to actually provide the documents, let alone the subsequent failures that kind of resulted from it. So you make a subject access request. You get, at some point, councils generally got 30 days to comply. You'll get your records back. So there'll be a big heap of paperwork or a big long email with lots of attachments and so on. Obviously it has to be done in a secure way. And that then should give you the full records. Everything that relates to you about that's held by the organisation has to be provided in a readable format. And it won't necessarily be coherent. It'll often be kind of in a higgledy-piggledy order. So one of the first things you actually should do is basically go through it and put it into some sort of order so you can follow it. But that will have the actual record system itself, what was done when did you ring them, what did they say, all those kind of things. It will include emails between professionals, which is often where it kind of gets kind of most problematic for professionals. And also, if you've been discussed at a multi-agency meeting of some kind, then basically the redacted minutes of that should be given you. So basically the minutes should be given to you, but everyone else's information should be removed. And with Bedford Borough Council, a number of times they've actually provided other people's data in these processes, partly because they thought that if you highlight something in black in a Word document, save it as a PDF, that you've basically redacted the data. You haven't at all, it's still there. And I've had to write to the council repeatedly to explain to them, you're actually breaching data protection law just by providing this information that you shouldn't be providing, which I still don't think they've actually taken on board. But anyway, that's their problem, not mine. So yeah, some will be redacted. There'll be copies of forms you've signed. So for example, if you signed a consent form, you'll have a copy of it there. You can see what you actually signed up to. And it's probably important to say that consent is legally problematic for a council, because when they make their homeless application inquiries under section 184, technically speaking, they shouldn't even be asking for consent. They have a legal overriding duty to do those. You can object to it and you could basically stop the application, but effectively the law says you should not ask for consent if you have a duty to do it anyway, which they do. And that just kind of underlines how important it is that councils comply with section 184 anyway. That's just an aside. So you've got all your records back, and when you look through them, you might start seeing your information being shared with professionals who you don't recognise. And I'll give you a couple of examples here. Let's talk about the MARIC, so the Multi-Entity Risk Assessment Conference. They're problematic for a number of reasons actually, but they're basically the kind of multi-entity meeting for people who are at risk of high-level domestic abuse. And generally in a MARIC, you're going to have the council chairing it, you're going to have the police there, probation, you might have the prison service there, you're going to have domestic abuse specialist services, you can have an IDVA there, safeguarding team potentially, lots of different kind of teams from across statutory organisations and some voluntary organisations. And let's say, just give you one example of many, let's say you've got a victim and a perpetrator, neither of whom are known to probation. So the perpetrator is not known to probation, the victim certainly isn't known to probation, and yet they have discussions about this individual victim and the perpetrator in the presence of probation, and they'll then share the notes of that meeting with probation after the meeting. Now, at that point in time, probation has got no legitimate reason to have that, Joe Bloggs' data on their system. And I mentioned probation because in Bedford I've had a number of breaches where they've mistakenly sent me stuff they shouldn't have sent me. So, that's kind of one reason I'm particularly sceptical of their data security measures they put in place. But that just illustrates the point that just because, probation are part of the MARIC, that does not mean that they're entitled to see everyone's data. If you're talking about Joe Bloggs' mental health issues and he or she has never been under probation, then probation have got no business knowing that person's information. That's just the way it works. One of the most important principles, I'd say, if not the most important principle of the Data Protection Act, is this idea of data minimisation, which is the fact that you should not do anything more than is necessary to achieve your aims. And in a situation where your job is to safeguard the victim of domestic abuse in this setting, probation, if they don't know them, have got nothing to offer in that conversation. You can't share information with probation just because they're part of the MARIC. Effectively, if you're going to do that sort of forum legally, you would need to ask probation to leave the room when a particular individual has been discussed, and only return to the room when someone they actually know and have involvement with is being discussed, and then not send them the minutes of everyone else to that particular officer. As I say, that would apply to lots of different organisations, not just probation, but that's just kind of maybe an obvious example. So you're going to kind of see situations like that. Another example, and I've talked about this on the channel before, worked with a guy, he was a victim of modern slavery, he was in priority need, he was owed the main housing duty, and yet, even though he was owed the main housing duty and was basically waiting to move into his social housing, the housing officer kind of wanted to get him out of TA earlier, so they referred him to supported accommodation without his knowledge, without his consent, and effectively that again was a breach of the Data Protection Act, and that's how we actually challenged it. We said, first of all, he doesn't want to go there. What's your lawful basis to share information about his mental health to this hostel? There's no way that they could do that based on their privacy notice and the information he'd been given. So you see lots of breaches like that. You'll sometimes see breaches where they've just literally sent it to the wrong person, although that's probably less likely they're going to provide that in the SAR. But I guess it's possible. Anything can happen in my experience. And there might be other evidence as well about, particularly when it comes to libel, things like risk assessments, things like criminal offences. If they get that stuff wrong, that's already a problem. And if they then share it to another organisation with or without a good reason, then they're going to be in particular trouble there. So as part of that SAR pack you get back, there should be risk assessments about you, which you can then basically kind of have a look at and see if there's actually good reason for those risk assessments to be undertaken. And once you're looking through these documents, the other thing you want to look out for is where there has been some kind of breach, it's probably working out how serious the breach actually is. Because some breaches, some things technically breach the Data Protection Act, but they're not going to really bother too many people. I'll give you a really kind of extreme example of that. Technically speaking, the example actually comes from a textbook I've got about data protection. So let's say you're applying to work in the Asda warehouse or something like that, yeah? I used to work in Asda warehouse in Bedford, which is why I'm using the example. And I fill in the job application form, and it basically asked me for my driving licence number in the form, but I'm not applying for a driving job, I'm just applying to work in the general warehouse. in that situation, technically that is a breach of the Data Protection Act, because they have asked for more information than they need to achieve the aim, which is to work out if I can work there or not. But that's not a serious breach, you know. That's I'm not bothered about that particularly. I don't think many sane people would be bothered by that. But obviously serious breaches when they start processing or sharing much more sensitive information with people who you don't want them to share information with. And in most cases you should have control over who that data is actually shared with. As I say, with the exception of criminal offending, that sort of thing, where they're going to share it no matter what, and it's quite obvious why that is the case. And so once you've identified the breach and you've established it is actually something which is distressing, and I'll probably on that point I'll mention an article which I'm probably going to be a little bit guarded about sharing on YouTube because it doesn't like this sort of language, but effectively I'll share the link on the description, but basically it was a case where a victim of serious assault, let's just say that much, was effectively her data was then kind of broadcast by the police service, and she actually says it was kind of like being assaulted again, you know, in terms of the impact that data being shared widely had on her. She kind of equated that to the original attack, the original offence. So yeah, I mean, just to make the point that data breaches can be incredibly distressing when, understandably so, when organisations are sharing or processing such sensitive data in a way which is clearly not sound. And so I'd say, in one sense, you don't have to kind of over egg the case and say I'm really distressed by this. It should be obvious that most serious breaches will be distressing. And I guess another difficulty that might come up, so I've been a little bit kind of haphazard here, but another difficulty you might have come up is that when data breaches tend to happen, they tend to be kind of tangled up with lots of other kind of breaches. So in the cases I've worked on recently, actually, these people were already homeless, there had been already failures towards them in terms of gatekeeping and been left on the streets and so on, and they then had this additional data breach happen. It's actually quite difficult really to kind of sort of separate out how much harm they've suffered as a result of the breach, how much of it was by being left homeless and so on. But in the most recent case I'm talking about, the 4.5k, they still got 4.5k, even though we probably couldn't point to the exact harm that had been caused by the data breach rather than all the other things that have been happening to her. So that's something to bear in mind, that it's, you kind of, when it comes to quantum, which is the fancy kind of term for how much compensation you get, it's not always going to be straightforward to explain exactly how much damage did this particular data breach cause in respect to all the other things that might have gone wrong for you. There are some other things to probably say which I'll go into on the training day that I'm going to do, but basically once you've identified the breach and you've identified the distress and other damages it might cause, in some cases it might actually cause kind of like material damage. So let's say that an organisation labels you as a Schedule 1 offender when you're not, and then shares that with other hostels. Other hostels might say we're not going to take him because we think he's a Schedule 1 offender. So there are actually going to be times when data breaches and libel issues obviously kind of then lead to material damage of some kind, some kind of physical effect as well as an emotional distress issue. And so once you've established the facts, the things that have kind of distressed you, you then basically just work through the council's complaint process methodically. My experience with Bedford in this £4,500 compensation claim was terrible, as in they kept essentially trying to justify the breach in different ways. But ultimately they settled it, so it's like, well, they were definitely wrong about it, but they kind of just threw lots of spanners in the work. They kind of threw lots of other arguments in the case which clearly weren't legitimate, and yet that's kind of, you kind of have to deal with that as you go through the process. So you have to go through stage 1, you have to go through stage 2. I would say in your stage 1 complaint you basically want to state how much you want, how much you think is relevant. And as I say, for a situation where, let's say an organisation shares the fact that you are getting support from mental health services, so that's special category data, and they share that to an organisation that has no business knowing, they've got no connection with you, they've got no prospect of working with you. In the case I'm talking about here, one of the partners in this multi-agency meeting was Bedford Prison, which is a male-only prison, and yet loads of female data was getting shared with them. That's clearly not okay, just without having to know anything else. So in a situation like that, that was essentially what led to the £4,500 compensation. There were some other kind of aggravating factors I think in that amount, but I would say asking for something between £2,000 and £4,000 or £6,000 is probably going to be reasonable. There's not a lot of information actually within case law which kind of gives you much certainty, but where an organisation is breaching and kind of losing control of serious sensitive data, that's the sort of figure you're looking at pretty much straight away anyway. So ask for the figures within the first stage complaint, ask for it again in the second stage. The chances are you're not going to get kind of any compensation at that stage, or they might offer you like 500 or something, which is clearly not going to be enough. Once you get to past the second stage point, the next thing you want to do is take the complaint to the ICO, the Information Commissioner's Office, which is really a really good organisation in general. The website's great. You can actually, going back a step, you can make the subject access request through the ICO's website itself. I've talked about that in other videos as well. But you take it to the ICO, they then investigate. They don't have the power, it seems, to recommend compensation, but what they'll effectively come back with is a decision, and what they'll say is whether or not the organisation appears to follow the law or not. And if they're basically saying, we've done an investigation and it seems that the organisation broke the law, they'll then say, you know, you need to take this to court to get compensation. So that's the point when you want to probably start involving a solicitor. Up until that point, I would say a lot of people can probably get that far without really that much difficulty, as long as you expect the whole nonsense that comes with the council complaints process or organisational complaints processes, where they just try and basically blame everything else and kind of deny responsibility first of all. That's just normal, so don't be deflated if you kind of get that first stage or second stage response coming back to say that, you know, they've done nothing wrong. I think that's fairly normal. Take it to the ICO, they then investigate, and then essentially approach a solicitor. Now, there are specialist solicitors that deal with this stuff, but it's not terribly complicated law. So as I say, you know, Will Flack, who's a housing lawyer, you know, he kind of deals with homelessness and stuff like that, he was able to essentially do what was needed to be done to get it onto a barrister and get the claim sorted out. So that can take some time. So this is not a quick result, but potentially if you're going to get that sort of figure at the end of being homeless, that's, you know, going to help you make your home, going to kind of go a long way to kind of helping move on from the whole situation. And as I say, I think it's going to have a real good impact in terms of positively affecting the standards and practices within the sector. So you're not only going to get compensation for yourself, but you're going to probably make the sector better for people who become homeless after you, and kind of actually get dealt with better. So for that reason, I think it's, you know, for both those reasons, I think it's really kind of important thing to do. I think that's all I want to say in this video. I will be putting some more videos about data protection in general. I do intend to essentially deliver the entire day's training course onto YouTube in the next couple of months. I've been meaning to do it for ages, so I just never have time, but that's my intention. And that training is not just about telling you how to get you know, kind of claim for compensation, although it will cover that. It's essentially acting as basically a good staff training anyway, so staff members actually understand what the law is and what they're required to do. And also I'm going to make it so that for anyone out there looking to set up a little organisation, a little charity or something to help other people, which is what I really hope people will, you know, kind of do around the country, it will also kind of give you the information you need to comply with the ICO, make sure all your policies and your kind of forms and all that sort of stuff are right, making sure your practice is right from the start. There's things like data protection impact assessments, which are really important and kind of necessary to establish what risks you pose to your clients in terms of dealing with their data. So yeah, all of those things has come, but I'm hoping this video has been useful in itself. I think that if you've got headspace for this stuff, it is plausible that you'll be able to kind of do most of this yourself. As soon as you've identified the breach, you know, and you know you're right, and again, I'll be putting more information about there to kind of know when a breach isn't a serious breach, that kind of thing. But I think it is then just a case of methodically working through the councils or the organisations process, the charities process. Just to say, I guess I keep saying council, charities are just as subject to the Data Protection Act as councils are. And yeah, I think charities are just as apt to break the law as councils are, to be honest. So yeah, hopefully that's been useful. As always, stick any questions you've got about this in the comments. I will take them to the next live stream, unless they're dead easy to kind of to respond to. Yeah, live stream every Thursday, well, most Thursday nights, sometimes it's a Wednesday. If you haven't checked out Will Flack's channel yet, Will Flack Law, check it out. He does a live stream most Mondays, where again we just kind of talk about this information, just kind of sharing this information. I'm hoping that it just helps people kind of unpick all this kind of, you know, legal jargon and kind of complication that comes through the law, and just puts people in a situation where they can actually start, you know, kind of actually making progress, challenging council decisions primarily is what it's really about, but also challenging other organisations who are acting unlawfully or acting immorally or whatever, unethically, and getting them to improve. So yeah, I'm sure there's more I could say about this, but I'll leave it at that for now.